So welcome to House Judiciary on Tuesday, February 13th. It's a Valentine's Eve. And we're going to go ahead and just start right out. As you know, we've kind of all been anticipating this hearing, and it's been worked on for weeks, months, and years. And so we're all anxious to hear what we've come up with. So I'm going to open the hearing on House Bill 2606 and ask Natalie, our advisor, to give us an overview, please.
Thank you, Madam Chair. House Bill 2606 specifies that certain drug offenses don't give rise to forfeiture under the our Asset Seizure and Forfeiture Act. It requires courts to make findings that a forfeiture is not excessive, restricts actions prior to commencement of forfeiture proceedings, requires probable cause affidavit filing and review to commence proceedings. It increases the burden of proof required to forfeit property, declaring convincing evidence, and it authorizes courts to order payment for attorney fees and costs for certain claimants. I'm going to start with just a little bit of background. So you all heard a bill last year related to civil asset forfeiture, and then Chairman Patton made a request to the Judicial Council that the Judicial Council review that legislation, which did happen, and there's a Judicial Council report containing their findings. At the same time, the Legislative Coordinating Council set up the 2023 Special Committee on Civil Asset Forfeiture. That committee met after the Judicial Council had issued their report and their findings. And I have a summary here of what the Special Committee on Civil Asset Forfeiture recommended to you all. So the first would be deleting offenses involving controlled substances that apply primarily to a user from the list of offenses that give rise to forfeiture, requiring seizing agencies to return property if certain timelines are not met, to engage an attorney or otherwise move the case forward, prohibiting pre-forfeiture waivers of rights and property, allowing a proportionality hearing be requested at any time, requiring a judge to determine whether there is probable cause and supporting forfeiture as a preliminary matter, requiring an automatic stay of discovery in forfeiture proceedings during criminal proceedings, establishing a seizing agency can be ordered to pay a prevailing claimant's attorney fees, and finally requiring the state to prove property is subject to forfeiture by a clear and convincing standard. So those were the recommendations from your legislative special committee on asset forfeiture, and all of those are contained in this legislation. So I'll go through the details here. Section 1 amends KSA 60-4104. That's related to the conduct that gives rise to forfeiture under the Act. Current law there in subsection B includes all violations involving controlled substances, which is Article 57 of Chapter 51. Under the bill, subsection B would only include violations involving controlled substances in certain statutes. Primarily, what we're doing there is excluding simple possession crimes and other crimes that are associated only with personal use of a controlled substance as opposed to distribution or manufacturing. Section 2 amends KSA 60-4106. That's related to property that's exempt from forfeiture. Current law there in subsection C provides that prior to a final judgment, a court shall limit the scope of a proposed forfeiture to the extent the court finds the effect of the forfeiture is grossly disproportionate to the severity of the owner's conduct. This provision is amended to require the court to determine whether the proposed forfeiture is unconstitutionally excessive. And the determinations that the court will use to make that finding are listed in section 6. So we'll talk about those. If the court has not made that determination earlier in the proceeding, then they have to go forward and make that determination at this time. Section 3 amends KSA 60-4107 related to seizure of property. Current law there in subsection G gives an agency 45 days after a seizure to forward a written request for forfeiture to the county or district attorney. This bill reduces that time to 14 days. The bill retains current law requirements that require the county or district attorney to accept or decline that request within 14 days. And it specifies additional timelines for action after that step in the process, which ultimately ends with engaging attorney and an outside attorney to represent the seizing agency or returning the property that's seized. This bill also adds a new subsection P, to provide that the seizing agency shall not request, induce, or otherwise coerce a person who has at any time asserted rights as an owner or interest holder of property to waive in writing those rights until that forfeiture proceeding has commenced. Section 4 amends KSA 604109. That's related to the commencement of forfeiture proceedings. Current law there in subsection A provides that forfeiture proceedings can't be are commenced by filing a notice of pending forfeiture or judicial forfeiture action. This bill amends subsection A to require filing an affidavit describing the probable cause supporting the forfeiture. After that affidavit is filed, further proceedings shall occur only after the judge has determined from the affidavit that there is probable cause to believe that the property is subject to forfeiture. The bill also amends subsection B to allow the plaintiff's attorney to file a lien for the forfeiture of property only after commencement of a forfeiture proceeding. Section 5 amends KSA 604111. That's related to claims under the Forfeiture Act. Current law there provides that only an owner or interest holder in property that is seized for forfeiture can file a claim, and that claim has to be mailed to the seizing agency and to the plaintiff's attorney within 60 days after the effective date of the notice of a pending forfeiture. This bill requires that the plaintiff's attorney file a notice of receipt with the court when a claim is received, unless that claim was already filed. And that filing is required to include a copy of the claim and the documents showing the date the claim was mailed and received. Section 6 amends KSA 604112. That's related to judicial proceedings that take place. The bill amends subsection C to provide that at any time prior to final judgment, an owner or interest holder can petition the court for determination or reconsideration of its prior determination that there was probable cause to move forward with that forfeiture. The bill amends subsection E to provide that if the court finds that there's no probable cause for the forfeiture, then the court has to order the property released to the custody of the applicant as custodian for the court or from a forfeiture lien pending the outcome of a judicial proceeding. As mentioned above, a new subsection G related to the proportionality hearings. There's a non-exclusive list of factors that the court is required to determine when determining whether a forfeiture is unconstitutionally excessive. At any time following the seizure, the person from whom the possession or control of the property was seized can petition the court to determine whether that forfeiture is unconstitutionally excessive. The plaintiff's attorney has the burden of establishing that the forfeiture is proportional to the seriousness of the offense by clear and convincing evidence. And then finally, in that section, subsection O is amended to require the court to automatically stay discovery against the criminal defendant and against the seizing agency in any civil proceedings during the related criminal proceeding. Section 7 amends KSA 604113. That's the in rem proceedings, which is the most common type of asset forfeiture. Current law there in subsection H provides that the plaintiff's attorney shall have the initial burden of proving that the interest in the property is subject to forfeiture by a preponderance of the evidence. This bill would change that standard to clear and convincing evidence. Section 8 amends KSA 604116 related to judicial disposition of that property. Current law there provides that the court's required to order a claimant who fails to establish that a substantial portion of the claimant's interest is exempt. They have to pay reasonable costs and expenses to any claimant who established that their property is exempt from forfeiture, and to pay reasonable costs and expenses of the seizing agency for investigation and litigation of the matter, including those attorney fees. The bill makes this order permissive instead of mandatory. And it also adds a new provision requiring the court to order the seizing agency to pay reasonable attorney fees and costs to a claimant in any proceeding in which the court finds that the claimant has prevailed by ordering the return of at least half of the value of the interest in the property. Subsection G there is new, and it provides that if there are multiple claims to the same property, the seizing agency shall not be liable for attorney fees and costs associated with any claim if the agency recognizes the claim, returns the interest of the claimant in the property, if that property can be divided. So if that portion, if it's able to be divided, then it has to be returned that way, does not cause the claimant to incur additional costs or fees, and prevails in obtaining forfeiture with respect to one or more of the other claims. Finally, Section 9 amends KSA 604117 related to disposition of forfeited property and the use of the proceeds. Current law there in subsection D and E require that each law enforcement agency deposit the proceeds from forfeiture into specific funds, which shall not be considered a source of revenue for normal operating expenses. They have to be expended by the agencies or departments through their normal city, county, or state appropriation process. And they have to be used for special additional law enforcement purposes, which are specified in subsection E there. And this bill adds that that money and the funds can be used for the payment of attorney fees and cost from the previous sections. And I can take any questions.
Thank you, Natalie, so much for that great overview. Committee, what questions do we have for the reviser? No questions. Okay, thank you so much. Committee, we are going to proceed now with the conferees. I first want to welcome Representative Haskins being with us today. Thank you so much. And I know Representative Landwehr is on WebEx. I think everybody else is here. And I am assuming that Representative Heiberger is watching, but not as a member of the committee. Do you know? Okay. Okay. Well, we miss him. So just so we know that. Committee also, we're going to go ahead and hear all the in-person proponents before we ask questions. Then we'll do the same thing with the opponents. And we're going to change the agenda just a little bit. I'm going to have Representative Stephen Owens go first. He was the chairman of the interim committee, and he's going to give us a little more of an overview. So he's going to go first, and just if all the proponents and opponents will be conscious of the time, we want to make sure we have plenty of time to get all the questions answered for both sides. So, okay, thank you. Please go ahead and welcome to this committee as a standing there instead of at your seat.
Absolutely. Thank you very much, Madam Chairwoman. And I'm honored to offer testimony on behalf and in support of House Bill 2606. To add a little bit of context to this bill, for those of you that may not have been a member of this committee in the past, civil asset forfeiture is a topic that has come up nearly every year that I've sat on this committee, and this is my 6th session. When this bill came up, it came up last year as House Bill 2380, and purported to swing the pendulum, in my opinion, 100% the other direction from where civil asset forfeiture is to where the proponents of that bill wanted to be. But having heard this topic over and over and over again, I believed that there was a better way where we could find a little bit more middle ground in that balance between individual liberty as well as the needs of law enforcement to ensure the ill-gotten gains of those guilty are not kept. And so we began meeting originally and trying to find compromise. We realized the session was too short and we were unable to do that. And so I put in a request that we have a special committee, and then I worked with Chairman Patton to make the request to the Judicial Council to have them study it. Judge Sexton with the Judicial Council did a tremendous amount of work with his committee, which represented the subcommittee of the Judicial Council, which represented judges, lawyers, folks from all aspects of this topic that got together and worked diligently, some of which you will hear from a little bit later. We intentionally set the interim committee to receive that report and to be able to hear their perspectives. And then we had an opportunity to hear from various stakeholders throughout the day. So first, I think it's important to realize that this bill truly is a compromise bill. Nobody got everything they wanted in this bill. There are people that are very passionate on both sides of it. But what I do recognize and what I do stand here in support of is this compromise language that represents that of the special committee that spent a lot of time studying this topic. These recommendations, even though my name is attached as the one introducing it, because a special committee doesn't necessarily introduce legislation. And so, but it is exactly that, the recommendations of our subcommittee, the vast majority of which were unanimously supported. So I truly believe this is a good bill. This is a good compromise piece of language. I look forward to hearing from the proponents, the opponents, and the neutral on this, but wanted to just add a little bit more context and realize that any piece of legislation that takes the reviser nearly 13 minutes to go over is a pretty in-depth bill. And I want you to know that that responsibility wasn't taken lightly by the members of the special committee or those involved in this topic. And so I'll be on this committee and stand for any questions if anybody has any. Thank you, Madam Chair.
Okay, thank you, Representative. We'll now call to the podium Dan Burrows with the Attorney General's Office. Welcome to committee.
Good afternoon, Madam Chairwoman, members of the committee. Dan Burrows, I'm the Chief Deputy Attorney General. I appreciate the opportunity to appear before you again on this bill. I want to make very clear that the Attorney General is very much in favor of this bill, encourages you to pass it without amendment for the reasons that Representative Owens brought forward, really. That this is the result of lots of hard work over a long time. If I understand correctly, the legislature has been repeatedly focused on civil asset forfeiture since at least 2017 and has not made, other than some reporting requirements, substantial moves towards reforming the process. The Attorney General thinks reform is good and necessary, and that this bill really represents something that both law enforcement and civil liberty advocates on the other side can come together and support. It does improve the process in ways that those innocent property holders that people are worried about really do have a better opportunity to challenge the forfeitures. We understand, as folks who have done civil asset forfeiture before and for whom most of the agencies are doing this at the state level or receiving their authority, that civil asset forfeiture is an important tool. There are cases in which it can and should be used. The example I always use is from when I was a federal prosecutor. It was a federal one, but it worked out the same way. We used civil asset forfeiture. We had a defendant who had committed bank fraud. By the time he was caught and reached trial, he was incompetent to stand trial. He couldn't be convicted. You couldn't pursue a criminal asset forfeiture, which the feds have. And yet, the guy had an RV that he'd purchased with the proceeds of his crimes. And the choice was either let the guy off scot-free or at the very least, take away the proceeds of his crimes. Now, in those unique cases, civil asset forfeiture is an appropriate tool. Now, we also understand that it is easily abused. And the Attorney General has taken steps within our office to review those cases much more stringently than we have in the past. But that review does not necessarily fix the due process issues that might come up. And we think this bill does. I was joking with one of my friends from Americans for Prosperity, who I understand has been supporting civil asset forfeiture. I said, look, the Attorney General just wants everybody to join hands and walk happily into the sunny uplands of a political compromise that nobody's real happy with. But that is how the political process works. This bill is the result of an extensive amount of work. We appreciate the work of Representative Owens, of Director Mativi, and all the others who have been on the committee and really looked at this closely. And we think this represents the legislature's best hope to fix any problems that may be in our civil asset forfeiture laws. We ask that the committee not let the perfect be the enemy of the good, but understand that this is a bill that, for the most part, everybody on both sides of this issue can get behind, absent just a few folks, and it's a good bill. With that, I will yield to any questions.
Okay, thank you so much. If you can stay, then
yes.
we'll do
Thank
questions at the end. Okay, I'll now call up Sam McRoberts from the Kansas Justice Institute. Welcome to committee.
Thank you. I'm Sam McRoberts. I am the litigation director at Kansas Justice Institute, and I'm here today to support this bill. I had the pleasure and honor to participate in the advisory committee over the summer, where we had robust conversations, robust debate, sometimes a few arguments, all about asset forfeiture. And I think coming out from that committee and hearing what Representative Owens said and what Dan just said, we agree. This is a good bill. It's not a perfect bill. If we could draft a perfect bill and get it passed, we would. But this is, I think, a really good way to deal with the problems that are commensurate with asset forfeiture. There are too many defaults. It's too hard for people to fight back against the seizures and the attempted forfeitures. And so this bill sets forth a number of ways to fix that. But I think three things that I'd like to highlight are the probable cause determination at the very beginning of the case. That was Director Mativi's idea. It was a fantastic idea. We support that. The second thing is changing the burden of proof, We think that the way it's written now is a marked improvement over the way asset forfeiture is currently set forth. And the third component is the attorney's fees provision. I mentioned quickly that there are too many defaults in Kansas. I think the committee report set that number at about 70%. So for 70% of the people who are in forfeiture, they just give up. We think that by having an attorney's fees provision that would allow people to get an attorney who would otherwise not be able to get into the case and actually press their claims and to hold the government accountable during the forfeiture process. So for all of those reasons, we do support this bill. We think it makes sense, and we would urge the committee to adopt it.
Okay, thank you so much. We may have some questions after a few more people. Yeah, thank you. Okay, now if we could have Greg Glod, Americans for Prosperity. It's my understanding he's on WebEx. Is that right? Okay.
Yes, I am. Thank you, Madam Chair.
Yeah, welcome to committee. We can hear you.
Excellent.
And now
apologies, I couldn't
you.
be there in person. I was at the airport for about 5 hours yesterday. Flight finally got canceled, so here we are. So I appreciate you accommodating me virtually here. My name is Greg Glod. I am the Public Safety and Criminal Justice Fellow here at Americans for Prosperity, and we are supporting on the bill here. We're for support. So as we've all heard, there's been a long process, and Americans for Prosperity has been involved in it. I was able to come out there in December for the committee, and the thing that I've worked on dozens of forfeiture bills across the country. It's one of the things I got started in 2015 when I began as a policy analyst in criminal justice. And I have been incredibly impressed by the process here, even though it has taken long and everything's bureaucratic everywhere. But how many interested parties came together to actually provide data, listen, bring those changes in, and there's just the curiosity of the entire committee, both on the House and Senate side, and then the special committee as well, to try to get this right. I've been really appreciative of that, and I think the best thing is that everyone wants the same thing, right? We want our streets safe. We want, the goods from either criminal activity or the things that allow for that criminal activity to happen to get out of, the criminal's hands. But we also want to ensure that people that are innocent, or even potentially not, have their own, the due process has protected them by the Constitution. I think this bill gets us a lot closer to that, particularly increasing from, preponderance of the evidence to about, over 50% to clear and convincing, a higher standard there. I think that'll be incredibly helpful, and a lot of the other provisions in the bill that I've already spoken on, I don't want to belabor that. But I do think that one thing I want to note, we see forfeiture. One of the issues is a lot of the money goes to, supporting law enforcement. I think that's an amazing thing. And we should support law enforcement, I think, better from a better funding source as well. And so I think allowing them to do the great stuff that they've been doing. I was just reading about the Kansas City police chief who is tackling fentanyl in a very productive way. I think those types of things should go around. Those are the types of things that actually reduce dependency on drugs. Those are the types of things that actually decrease crime in us, supporting law enforcement at the front end, allowing prosecutors to actually have, bandwidth and resources to do this, around police to have bandwidth and resources on it rather than other things. And so I think this is a great start to continue. And I really, really encouraged by the process thus far. And so I'll pause there, and hopefully I can have you answer any questions later. Thank you.
Okay, thank you so much, Mr. Glad. We appreciate that. And we'll get back to you if people have questions. Now we have Tony Mativi from the Kansas Bureau of Investigation.
Good afternoon. Thank you, Madam Chair. Thank you for the opportunity to present testimony on this bill. This has been an interesting day because this morning I was downstairs testifying in opposition to the Senate bill. And the reason is because this bill is a direct reflection of the committee's work over the summer, and that bill added several additional provisions beyond the committee's recommendations, and they were sufficient to cause me to oppose that bill. Let me back up a step. Civil asset forfeiture is an incredibly important tool to law enforcement because we use it to target drug traffickers, human traffickers, sex traffickers, and complex criminal organizations. And it is a very effective tool. Although the vast majority of civil asset forfeiture cases arise from traffic stops, we at the KBI use it. We're not in that lane, if you will, but we are using it right now, today in Kansas, to target and to try to dismantle a significant drug trafficking organization in our state. And the way we're using it is to go after the properties that this organization uses to receive drug shipments, to house them, and then to distribute them out. Okay. So unfortunately for all of us, criminal organizations are sophisticated. And those properties are going to be layered under LLC after LLC. And asset forfeiture, civil asset forfeiture, is a tool that allows us to go after the organization by taking that property away from them so that they can't use it for that purpose anymore. We have to have that tool available so that we can do work on behalf of you, on behalf of our constituents and citizens of Kansas. I, like Mr. McRoberts and members of this committee, had the pleasure of serving this summer on the standing committee, which was made up of thoughtful and well-intentioned people who had very strong views on both sides of asset forfeiture. And to me, the purpose of that committee was to figure out how do we address the concerns of folks like Mr. McRoberts, Representative Mon, Representative Osman, who wanted to protect the innocent property owner, but at the same time make sure that this very effective tool was still available to law enforcement. And I believe that's what the committee did. And I believe that that work is reflected in the recommendations, which in turn are reflected in this bill. And that's why I support the bill. The four major factors that have already been discussed, the probable cause determination at the beginning of the case, the narrowing the offenses to exclude simple possession, the fee shifting, and the increasing the burden of proof. I believe they provide a substantive measure of due process for any innocent property owner. But at the same time, those changes aren't going to compromise law enforcement's ability to use this effectively as a tool. And that's why I agree this bill is middle ground. There's people on the law enforcement side who don't like things in the bill. There's people on the other side who don't like things in the bill. But at the end of the day, to me, this is an effective compromise. It is a good solution. It provides additional protections, but allows us to keep using the tool. And for that reason, I urge you to pass this bill. Thank you, Madam Chair.
Okay, thank you so much, committee. Those are our in-person proponents. Let's go ahead and ask questions for those of you who have questions. Okay. Committee. Representative Osman.
Thank you very much, Madam Chair. I'll let Representative Carmichael talk to the questions itself. I actually don't have a question because I've talked through this quite a bit. I just wanted to call out a number of the members of the committee that actually worked extremely hard as well to put this together. Especially, I want to say to Director Mativi that I think that you and I might have very different opinions on what makes a good bill on civil asset forfeiture in terms of like what I would have put in versus what you would have put in. But I think that honestly, this bill as it exists right now is a fantastic example of compromise, and one that would not have come about had it not been for your hard work in committee over the summertime. So I really appreciate your thoughtful effort in bringing this bill to fruition.
Thank you. Committee, Representative Goddard.
Thank you, Madam Chair. One thing caught my eye, and it seemed like a pretty drastic change, and that was in Section 3 of the bill. Under current law, an agency has 45 days to forward a written request for forfeiture. This bill, according to what I have here, reduces it to 14 days. To me, that seems like a pretty significant change. And I want to know what the effect of having 31 days removed from the time frame would be on the agency requesting forfeiture.
Okay, thank you. Is there anyone in particular that you'd like to ask?
No, and maybe this is a better question for the opponents than the proponents, but I thought I'd ask it now. Sure. I might ask it later on.
Okay. Would any of the proponents like to speak to that question? Yes, of course.
That
Go ahead and
pause.
introduce yourself again.
Thank you, Madam Chair. Tony Mativi from the KBI again. That pause was reflective of the fact that there are folks on the staff at the KBI, one in particular who knows far more at a granular level than the boss does. Sarah Washburn is one of our incredibly talented and capable attorneys, and she explained to me that it's not as dramatic a reduction as you might think, because there are actually two 14-day periods that get stacked. 14 days for the county attorney to decide whether to initiate a proceeding, and if not, then another 14 days to try to hire outside counsel. So it shrinks the 45 down to 28. So it's still a shortening of the process, which is something that the folks on the other side were very much interested in, but doesn't make it so short that we thought it was unworkable from our side.
Thank you. I'll be interested to see what the opponents have to say about that.
Yes, sir.
Thank you. Thank you, Madam Chair.
Makes sense. Representative Carmichael.
Thank you, Madam Chair. My compliments to everyone involved. Couple of things I want to make sure that I'm clear about. First, to whomever it is from the proponents, straighten me out if I'm wrong, but I think in reaching this compromise, we have left the disposition of the proceeds of the forfeiture, what agency gets what and how much, etc. I think we've left those concerns for another day, as opposed to what some of us feel, and that is that we ought to adequately fund law enforcement, and that we ought to send the proceeds of forfeiture to the state general fund. And someone let me know, because I think we're not touching that aspect in this bill. The director is here. I mean, he said, I'd like to hear from the director. Well, he's not smarter than you, but he has JD after his name, whatever that means.
Tony Mativi from the KBI again. You're correct, sir, that we're not touching that. We're leaving it for another day. It is not something that we were able to reach a consensus on. There's a lot of differing opinions. I, for one, push back very hard on this notion that asset forfeiture is policing for profit. If you listen to some of the sheriffs in the room and ask them what they spend their asset forfeiture money on, I think you would find that it is things that you would want them to spend it on. Drug eradication programs, training, education, equipment, funding their canine program. Very worthwhile and valuable purposes that then that money doesn't have to come from the general fund. It's not taxpayer money to do that. There's other options like drug courts, victim restitution. There's a lot of different things that you could do with it in theory, but at the end of the day, we were trying to come to a reasonable compromise, and that was an issue that we had to leave for another day in order to reach the compromise.
And thank you, Director. I think it's wise to leave that issue for another day because obviously there is professional disagreement between many of us in this room. My second question, Madam Chair and Director Matavia, I assume you didn't come here to be the quote poster boy unquote for this legislation, but
Happy to sit back down.
yeah, and I'd be happy to hear from Mr. Burrows because has good expertise in this area as well. So let's do that if you don't mind. There's a phrase in the law of forfeiture that escapes my mind right now, and it's when the local authorities defer, if you will, to the federal authorities so that the same seizure can be processed pursuant to federal law rather than state. And I don't want to use up my two questions. But do you remember somebody remember what the name of that is? It's just escaping me.
I don't know that there's a technical term. I would say they've referred it to the feds. I think there's another referral that that's correct. That also is not addressed in this bill, again, because I believe there was a lack of agreement between the parties. I did address that specifically in my written testimony in the Senate because the Senate bill does address that specifically. I, like Director Matavia on the other issue, honestly don't understand the objection. My experience as a federal prosecutor is that a large portion, perhaps the majority, I don't have the statistics in front of me, but of federal forfeitures are criminal forfeitures, not civil forfeitures. And so prohibiting people from referring it criminally in some sense works against the people who say, well, you ought to have a criminal conviction in order to forfeit things. In criminal forfeiture, the forfeiture is ordered as an element of the criminal sentence after either a guilty plea or a conviction beyond a reasonable doubt in a jury trial. And I think that it also creates complications with local law enforcement because a lot of local law enforcement work on task forces, especially in relation to drugs and human trafficking and other things like that, with the feds, and it would make it almost impossible for them to work in that system if anytime the feds were going to do a forfeiture, which under Department of Justice policy, at least when I was working at the U.S. Attorney's Office, was required every time it was authorized in when you put forth a criminal indictment to have a forfeiture allegation, it would make it almost impossible for them to work together with federal authorities. But nonetheless, again, not addressed in this bill.
Mr. Burrows, my question was merely what is the name of the procedure?
I don't
had it at hand. You're convincing me to vote against this bill. Just let's just leave it at this, Madam Chair, that it's probably best that we not get into this topic here today because we could spend a lot of time destroying this compromise, arguing points that I've just heard from Mr. Burrows.
So
thank you.
I will call on the reviser to give us the answer to your question.
Oh, that'd be excellent.
Thank you, Madam Chair. It's called federal adoption.
That's exactly the word I was looking for. Thank you, Madam Reviser. I'm sorry I troubled you, Mr. Burrows. Thank you, Madam Chair.
Committee, do we have other questions? Representative Goddard.
Thank you, Madam Chair. Not being an attorney, maybe this is for the reviser, I'm not really sure. But in Section 7, property subject to forfeiture would be by a preponderance of the evidence. And this bill would change it to the burden of proof to clear and convincing evidence. Can someone explain to me the difference between the two?
I think that would be a good one for the reviser.
Thank you, Madam Chair. There's, these these requirements to prove things by a certain standard, they're a little bit amorphous. There's not like one definition that's used across every court. Essentially, the kind of common way to think of it is a preponderance of the evidence is kind of 50.01%. It's, more than half likely than not that, in this case, that the property would be subject to forfeiture. Clear and convincing is more that the evidence is highly and substantially more likely to be true than not. So, I mean, some people say 75%, I've heard that before. Again, there's not really clear-cut definitions for those, but clear and convincing is definitely a higher standard than preponderance of the evidence. And then beyond that, you have beyond a reasonable doubt, which is even higher than clear and convincing.
Thank you for that explanation. So it really boils down to interpretation.
Madam Chair, if I may, on the screen, Greg Glod with AFP.
Yes, go ahead. Thank
Sure.
you. Go ahead.
This is from an 84 Supreme Court case, but this is still hasn't been overturned at all. That they say clear and convincing means that the evidence is highly and substantially more likely to be true than untrue. In other words, the fact finder must be convinced that the contention is highly probable. So I think that 75% is about right. It's not beyond reasonable doubt. It's not more likely than not. It's that in between, kind of the intermediate. And that's Colorado v. New Mexico. If anyone wants a citation, it's 467 US 310. That's 1984. Thank you.
So just a follow-up question to that would be, it's really more than just the interpretation. There are different standards, and the standard was changed. It wasn't just that the interpretation has changed. Would you agree with that?
Yes, I think, yeah. And then there's kind of that in the eye of the person. So you have kind of what the definition is, and then what do you feel is highly probable? So there is like an objective aspect of this where you have some definitions, and there may not be one for Kansas, but this feels like that. And then there's the subjective aspects of it where you're like, hey, is this more highly probable? It's how a jury would, for beyond reasonable doubt. Was I convinced beyond a reasonable doubt or not? It's the same standard, but it's the interpretation of the fact finder.
Thank you for that explanation. Thank you, Madam Chair.
Committee, do we have any other questions? I do have one question for Mr. McRoberts, or this could be Mr. Glod, but my question is, today I feel like the proponent testimony was really high level, and we didn't get into the nuts and bolts as much as we have otherwise in years that we've heard this. And I'm looking around, I think maybe Representative Curtis, I think Representative Carmichael, I can't remember Representative Smith when you joined Judiciary, but there are a few of us that were here in 2017 when we first heard this bill. And it was very much about how it affects a specific person. So could you just give us a quick rundown about, we've heard a little high level, but how might this actually affect a person who is in the situation?
Thank you. Sam McRoberts from Kansas Justice Institute. So I'll try to work my way through the process as best I can, but it's probably better if while I'm doing that, somebody asks clarifying questions. But the way that I have thought through forfeiture, and Director Mativi and others feel free to jump in, but take, for instance, a traffic stop. So let's say that law enforcement stops a vehicle and law enforcement is asked the person to step out of the car. Law enforcement runs a drug dog around a car. The dog alerts. The police officer, law enforcement thinks they have probable cause to search the vehicle. They search the vehicle. They find cash in the car, and they believe that they have probable cause based upon the dog alert that there were drugs or drug paraphernalia within the car. Then if the law enforcement officer thinks that there's probable cause to seize the cash, then they can do that. After that, then they would initiate the forfeiture proceedings. They can file a notice of pending forfeiture that triggers certain timelines. And that gets into, and I don't want to muck this up by now opening up a debate, but what it does is it triggers a requirement for that person to try to get their cash back. If they miss that deadline, then they're going to default. if they file their documents, that allows the government to then file basically a judicial petition. Then the individual has another deadline to be able to respond to that. If they miss that, then they default. So the way that, from my perspective, the way it impacts a person is if that individual says that cash was not proceeds of a criminal transaction, if that wasn't proceeds of, a drug purchase or a drug sale, then they have a burden to then file paperwork. If it proceeds to a trial, the government has the initial burden of proof. Then if they meet that initial burden, it flips to the person to establish their own burden that it wasn't connected to drugs. That's kind of like the best that I could quickly do right now. But that's how it would be. So if you don't have an attorney, that's going to be incredibly complicated. I've said this repeatedly, that if I would encourage everybody to sit down and look at the forfeiture statutes from start to finish. It is a complicated process. It is very difficult. It's very difficult for attorneys to learn, and it would be very difficult for individuals to try to navigate that without help.
Thank you. Thank you. I appreciate that. Representative Curtis.
Thank you, Madam Chair. So that's why 70% of the people give up.
So that is why I think 70% of the people give up. I would surmise that law enforcement takes a different position, which is that people give up because the proceeds or because the cash was related to drugs. And Director Mativa and I have probably argued about this a lot. I think that the data supports my view. I'm sure he's got data that supports his view. But I think just looking through the statutes and the level of money that's taken, the percentage and how low that dollar figure is, suggests to me that people are they can't get an attorney. They don't want to pay an attorney $5,000 to try to recover $500 or $1,000. It just doesn't make any sense. And trying to navigate that process on their own doesn't make sense either, because it's just too complicated.
Uh-huh.
So I imagine that most of the people that find themselves in that situation where they are just faced with either giving up or they give up because they don't have the time and the resources to fight it.
Yes.
And to clarify, you think this bill remedies that?
So I think that this bill is a really good way to try to cut down on the defaults. So I don't think that there is a magic bullet other than requiring a criminal conviction before property is taken. That is, to me, the magic bullet. But if no one is going to consider that, then I do think that this is a good option, because it does require law enforcement to fill out the probable cause affidavit. So rather than just saying, well, we found cash in a car and maybe the drug dog alerted, in the past, maybe that would have been sufficient to start this forfeiture process. But now law enforcement's going to have to sign an oath under penalty of perjury that there is a connection between that money and whatever nexus is for forfeiture. So I think that's a really good start. And I think that the attorney's fees provision is another way to make sure that people's rights are being protected, because now an attorney might be willing to take on $1,000 case because there is this prospect of attorney's fees. And I know upstairs we were talking about, or there were some law enforcement officers who were saying, well, law enforcement shouldn't be penalized if they lose the case. But attorney's fees provisions aren't a penalty. It's the same reason why in federal court, if you sue over a First Amendment violation and you succeed in that case, you are awarded attorney's fees. And that is to encourage attorneys to engage in that type of litigation. So it's not a penalty against the government, as I see it. It is a way to make sure that individual rights are being protected by having an attorney help shepherd them through the process.
Thank you. I think Mr. Glad, you have a comment on that?
Yes, certainly. I was just going to kind of go in a little detail of, how this is going to improve the forfeiture laws here. And so essentially, since the property is actually the thing on trial. And so in a criminal case, it's the person. So it's, the state of Kansas versus Thompson or whoever else it is. In a civil case, in a civil asset forfeiture case, it's literally the property that's on trial. So you don't get the same protections that are afforded to you in a criminal case, like certain evidentiary standards, how you're getting evidence, all these other things. And so you have these cases of like Kansas versus like $12,000 or something like that. And so what this bill is going to do is essentially, we all agree that someone should still get due process when they're having to go through this process. It's just what levels allow you to feel that you're doing your constitutional rights and protecting those of the citizens. And so that's where we see the improvements of the bill. It is protecting those, procedural due process, protections that we want to see someone before, the government, deprives them of their property. And so, for example, increasing the burden of proof to that, that is incredibly, helpful. That's why we have in a criminal case beyond a reasonable doubt. We don't want to deprive someone of their life unless we are very, very sure about what just happened. And so the probable cause hearing, that's so important because you're going to have a judge kind of writing that off, almost like a warrant in a lot of ways. We obviously wouldn't want law enforcement just to go into people's homes without having that check unless there's exigent circumstance and things like that. So that's going to be incredibly helpful to have that judicial check initially. I think that can kind of help shape the case as well and help expedite a lot of these things. So I think that's going to be fantastic to do. And so I think those are the types of things that we're seeing that can really just kind of beef up that due process protections for an individual. So we can ensure that the people that are funneling through the process, the innocent ones, are being able to be removed from this, and the ones that actually are guilty continue to go down that funnel, and we're able to do this in a much more expeditious and right-sized manner. I'll pause there.
Okay, thank you so much. And I'll call on Mr. Mativi, Director Mativi, to comment also on the same thing.
Thank you again, Madam Chair. Tony Mativi from the Kansas Bureau of Investigation. One of the things that Mr. McRoberts and I agree on, and others, is the level of default is very high, 70%. That's a very high level of default. What we disagree on is what drives that, and that's where there's no data. We don't know whether somebody defaults because the system is too complicated. The system is complicated. There's no doubt about that. Mr. McRoberts' recitation of the process was correct, but it didn't take into account some of the notifications that the plaintiff or the government sends to whoever was in possession of the property that notifies them of what they need to do and how they need to do it. So there are more protections than you might imagine, but it is a complicated system. But there's another reason for a default. Say, for example, one of the colonel's troopers stops a vehicle, drug doc hits on it, they find a false compartment with $350,000 in it. Okay, if the guy in the car says, that's not my money and I don't know anything about it, okay, that's a default. Okay, he's not going to contest when the Highway Patrol or their attorney files a forfeiture. Okay, when somebody gets caught on their way to a drug transaction with a kilo of cocaine, and the sheriff seizes the vehicle, and that person walks away, is he walking away because the system is too complicated, or is he walking away going, okay, you got me and you got my car, right? So you take that 70% and you try to break it down, and we can't do that because there's no data there. That's one of the areas where we're just not going to agree. But what we can agree on is the provisions in this bill add a meaningful layer of due process to help protect that innocent property owner. Whether that innocent property owner is 1% of the 70% or 50% of the 70%. Even if it's only 1%, they're still going to benefit from that protection. Thank you, Madam Chair.
Thank you. Representative Owens.
If I could just add maybe a little bit more context, because you're right, we did kind of skate over some of the substance. I would really encourage everybody to review the report from the special committee, and then even to go back and possibly spend some time looking at the testimony, because what we're not getting in here is some of the data that we saw within the committee. For example, one of the things we did in the legislature, I think 4 years ago, was created a reporting requirement for civil asset forfeiture. So the KBI kept a repository of all cases and the data and the statistics. And it was quite remarkable, some of the statistics that we saw. We found that the median forfeiture was about $3,000. It means that half of the forfeitures were less than that. And when you think about how expensive it is to hire an attorney, you're certainly not going to hire an attorney to go fight in a civil case for you for $3,000 or less, which again, depending on your perspective, lends itself to wonder, is due process really being at play? We saw forfeitures, if I remember right, the lowest one was $76. Okay, that's certainly the outlier, but it's this type of data that we heard and we saw, which really helped us guide down this path. So I was really grateful for that information that was provided during the hearing. I could go on about some of the specific pieces and the specific recommendations that were put in here. For example, requiring an automatic stay of discovery in a forfeiture proceeding during a criminal proceeding alleging the same conduct. That is significant when you consider the differences between the criminal process and the civil process. There are so many pieces of this that make sense. For example, deleting offenses involving controlled substances that apply primarily to a user, right? So we're talking user level quantities, right? Doesn't make sense. So I would just encourage people to dig in. I know we only have so much time, and the special committee spent, I believe, a little over 9 hours working on this. But there really is a lot more data and a lot more information. And of course, I'll make myself available to anybody that wants additional information.
Thank you. Appreciate that. And remind me if the committee report is in our.
It is. Yeah, I had requested that, and you had approved that to be sent. So the special committee on civil asset forfeiture report is in every one of your inboxes for your review.
And along those lines, the Judicial Council also, of course, had a special committee, and their report is on the Judicial Council website. So you all could go get that report also, which I would recommend. If you want to dig in, I would recommend both of those.
And I might add, Madam Chair, just quickly on that, the subcommittee of the Judicial Council made recommendations. The Judicial Council as a whole stayed very mute on this point and decided it was a policy decision. So that was the work of the subcommittee, just in case you do go there to understand that. Thank you.
Advisory committee. Yeah. Okay. Thank you. Or do we have other questions for the proponents? Representative Mon.
Thank you, Madam Chair. Mr. McRoberts, first of all, while you're coming up, I'll echo Representative Owen's remarks. Both the committee, the special committee on this, and the Judicial Council Advisory Committee recommendations should really be looked at. I mean, Director Mativi and I can come together on something. I think we're pretty good. So it really should be looked at. This is a good compromise bill. But Mr. McRoberts, I'd like for you to talk a little bit about the importance of the increase in the burden of proof, if you wouldn't mind.
So I think there are two things that are very important about that. One, as I would imagine it, the government attorney who's now trying to figure out whether to proceed with a forfeiture case has to take this higher burden of proof now into consideration. And so if it were a 50-50 case before, and there were no attorney's fees provision, maybe the government would be inclined to roll the dice on that case and say, well, it's a 50-50 case, no harm, no foul, let's just move forward and see if we can win on this. Now there's an elevated burden of proof that they're gonna, and before Mr. Glad kept talking about the fact finder, here it's gonna be the fact finder is the judge. So this is a bench trial, excuse me. So the government now has to consider whether or not they can prove their case to a judge at a higher burden of proof, this clear and convincing standard. And so that, I think, is going to affect, or hopefully it's going to affect, the types of cases that are being brought. And I also think what it does is it does have a real life practical effect if you're going to actually get to a trial on the forfeiture case, because now a judge is going to consider and will know the difference between clear and convincing and preponderance of the evidence. Will take that into consideration and then make the decision at the bench trial whether the government has met their burden of proof. And the way that I think through it is in a criminal case, for example, if the question is whether or not there's probable cause versus proof beyond a reasonable doubt, those are two different standards that judges are very familiar with. They know how to apply to those facts, and it's an easy thing for courts to do because they do it day in, day out in hundreds, if not thousands of cases. So from my perspective, the fact that the burden is increasing will make a difference, again, both at the initial decision to charge the property and then at the bench trial.
Okay, committee, any other questions? Okay, I'd like to draw your attention to the written proponents: Glenn Burdew, constituent, Tim Tarkelly, on behalf of the Libertarian Party of Kansas, Sheriff Curry Myers, on behalf of Johnson County Sheriff's Office, Rashane Hamby, Director of Policy and Research, and American Civil Liberties. And we have also neutral testimony that is written on behalf of Colonel Eric Smith, who we've had on the committee, Superintendent of the Kansas Highway Patrol. And now I will go ahead and we'll hear from the opponents at this point. I will call up Sheriff Jeff Easter to come talk to us, and welcome so much to our committee, Sheriff.
I appreciate that, Chairwoman Humphreys and committee members. Appreciate the opportunity to speak to you today. I'm Jeff Easter. I represent the Kansas Sheriff's Association as their legislative chair. This one is a little bit difficult because we could either came in as a proponent, neutral, or opponent, plain and simple. 99% of the bill we absolutely agree with. After speaking with KSA representation, who I answer to on this, the only issue that we would like to have clarification on is having to do with the fees that are assessed if changing the language from shall to may. There is different technicalities that could come into play that could get the case dismissed, and then we're responsible when there was enough probable cause, those type of things, if the paperwork got filed wrong, those type of things. That is the general concern. So it's difficult because we support the majority over the majority of this bill, absolutely do, and think that the change is very good for all the work that this committee did to come up with this kind of compromise, because we're not going to please both sides, there's no doubt. And so the other thing that I'd say is that we appreciate that if this committee and the House and everybody votes for this bill, that there is an avenue to pay for those fees, which comes out of asset forfeiture. So we do appreciate that. And we'll respect if this stays in the bill, what this governing body decides, we will respect those wishes. The other thing that I'd like to comment on, if you don't mind real quick, Representative Goddard asked about the time frame being cut down. We are supportive of that from the KSA standpoint. Currently, right now, if you have a criminal case, we have 72 hours to file that as an in custody where they're still in jail. In several counties, including my county, we already file probable cause affidavits, and there's a timeline that's set by my DA's office. And so either we have probable cause or we don't. And so within that 14 days, I think, is that reasonable to file the probable cause affidavit of why we have seized a piece of property and why we're asking to forfeit it. And so with that, I'll stand for questions. However, I have to be back in Wichita at 6:30 for a speech that I'm supposed to give. So.
Okay, I think we'll go ahead and take questions then.
If you don't mind, I'd appreciate it.
You don't want to. I know exactly how long it takes to get to Wichita.
Yeah.
Okay, committee, do we have questions for Sheriff Easter? Representative Osmond.
Thank you very much, Madam Chair. Thank you for your testimony. Could you give me clarification as to what specifically your opposition is in terms of shall versus may? Because is there a particular portion of the bill that you're referencing here?
Yeah, so, I know that Director Mativi and RDA down in Sedgwick County were the ones that proposed this portion of the bill, and I didn't necessarily have issues with it in the beginning. So in Section 8 F2, it talks about that the judge shall impose those fees. We're simply asking that if that shall can be changed to may, because the judge knows the intricacies of that particular case. And if law enforcement messed up, then they're able to assess those fees to us. And we understand that.
Would you mind clarifying, please? If you said that your DA proposed this change, or the change that you're opposed to, or the change?
So Director Mativi and Mr. Bennett
Mhm.
were the ones during the committee
Yeah.
meetings that proposed this compromise with the fees. That's why this has been difficult to say whether we're a proponent, neutral, or opponent.
Okay, I see.
And so all the KSA is asking for is for consideration of changing the word shall to may, and it gives that judge that discretion.
Okay, thank you. Committee, do we have any other questions for Sheriff Easter? Okay. Oh, I'm sorry, Representative Goddard.
Thank you, Madam Chair. Sheriff Easter, lights and siren on the way back to Wichita.
No, no.
Thank you, Madam.
I'm going to be late, but it's okay. So I appreciate you giving me the opportunity to answer the question.
Safe travels.
Thank you.
Thank you for coming to committee. Okay, if we could now have Chief Daryl Atterbury from Bel Air Police Department. And you can go ahead and introduce yourself, who you're representing.
Daryl Atterbury, and I'm representing the Kansas Association of Chiefs of Police, Chairwoman Humphreys Committee. We are also of the opinion that we like about 99% of this bill. We really appreciate the work that the committees, the Civil Asset Forfeiture Advisory Committee put into this. And I've spoken with a couple. You know, as a taxpayer, it's great to see both sides come together and work through all the details and come to something like this, because I think this is the way it's supposed to work. And I think it worked well. We believe that the proposed changes are workable and really don't undermine the law enforcement purpose in the state of Kansas. The one thing that we have an issue with is also the fee structuring, the way it's set, where that 50% works into it. And we would also ask that be changed from shall to may. And the reason for that is also, we believe that the judge is going to have intimate details of what transpired in that stop, in that contact. And I'm going to back up just a little bit. That contact isn't necessarily always going to be drugs. In Section 1, it talks about some of the things that asset forfeiture can be used for. And some of those things include identity theft, fraud, human trafficking, gambling, commercial gambling, criminal discharge of a weapon, theft, you know, many, many different things, not just drugs. So we think that the judge hearing those cases is going to have that intimate knowledge of that particular case and determine whether or not there was a mistake made, or even worse, maybe bad faith on the part of law enforcement. And that judge should have the opportunity to make the decision on that assessment of fees, rather than just having this boilerplate legislation go through. So again, I want to thank all the people that worked on this. I think this is a very workable solution to a very difficult project or problem. And with that, I'll stand for questions at the appropriate time.
Okay, thank you. If you can stay for just a moment. I'm thinking we'll go ahead and hear the other opponent and then do questions after both. And so that's kind of what we did with the proponents, making an exception for Sheriff Easter. Thank you. Appreciate you. Okay, Chief Paul Schlifke. How did I do? Okay, from the Wamego Police Department. Welcome to committee.
Madam Chairwoman, members of the committee, I represent the Kansas Peace Officers Association. And instead of going over the same ground, we concur with the other testimony. This is a good bill. The one thing that we would ask is that the word at the top of page 18, the word shall be replaced by the word may, for the same reasons. We all want transparency in any criminal or civil process. That keeps the trust between us and the public. And we just feel in this particular case, the language of may would give the judge who's familiar with the case a little bit more latitude to make a decision rather than forcing his or her hand. And instead of going over the same ground, that's our stance, and I stand for questions as well.
Okay, thank you so much. Representative Lewis, you had the first question.
Yes, it's directed. I can direct it to this gentleman. Thank you, Madam Chair. And it goes to this issue of the shall versus may. And I share your concern that, you know, it's sort of a one size fits all doesn't work given the intricacies and the complications that can arise in these cases. On the other hand, I appreciate the fact that if the claimant fails to show that at least half of the aggregate value is forfeitable, that it does suggest that they lost the case, if you would. So I guess what I'm going to ask you is, what if we said instead of may, instead of shall, we said presumptively shall? In other words, there's a presumption set up if that happens, but it doesn't restrict the judge's discretion completely.
Well, again, I speak on behalf of the KPOA, so I would have to take that to the president and the board, but it definitely, personally speaking, it definitely is like everything else. So it sounds like a great compromise for this bill.
Any other questions for the opponents? Representative Osmond.
Thank you very much, Madam Chair. And thank you for your testimony for all the opponents. I'm actually, you know, as I haven't had the opportunity to read fully your testimony as it's written, but I will be doing that very shortly. But I'm glad that there is there's not as strenuous of an opposition to this bill, other than some small portions of it. As it relates to section or page 18 on shall, specifically subsection A, the concern I think would be about trying to find effective representation for seizing entities or for seizures that have happened. And if an attorney, if it goes from shall to may, there might be a likelihood that an attorney will not take the case, knowing that attorney fees may only be reimbursed should they prevail, rather than definitely will. And their livelihood is staked on that shall versus may. So how do we go about finding a resolution to that portion, or is the concern solely on the attorney fees versus anything else in the subsection?
The concern, in my opinion, from the KPOA is that you're, again, backing the judge into a corner. We recognize we want everyone to have a fair and equal chance in court. And it's been said that someone who acts as their own attorney has a fool for their attorney, someone who represents themselves. And I certainly understand that. I guess it's just how this committee would decide the best way to remedy that.
Thank you, Madam Chair. I'd just like to see if at some point the reviser could take a look in Kansas and see if the phrase presumptively, not the reviser, the legislative research, take a look and see if the phrase presumptively shall is a phrase known to Kansas law. It's known to California, it's known to Ohio, Massachusetts, but I don't recall that any courts constructed that in Kansas. And before we start to develop a new phrase in Kansas law, I would appreciate it if they just take a look. That's all I needed.
Okay, very good. We'll ask them to do that. And I'm so curious, did you know that off the top of your head, or did you just do a little bit of research?
You know, I wish that the lawyers on this committee could get Westlaw. Instead, we just have to use Google.
Are there any other questions? Representative Titus.
Thank you, Madam Chair. Chief, always good to see you in Topeka. Would it make a difference, given that you gave three different entities testimony here with that offer together, if we considered the May for smaller municipalities and entities, because there are some very small police departments and very small cities that could be subject to this? I don't have a specific proposal, but is there a line there that could make a difference? And is this even a resource question? And I don't know if that makes sense.
That's a great question. Again, that's something I'd have to take back to the president and the board, but that, I mean, that's always something to consider.
Committee, any other questions? Representative Smith.
Trying to figure out how to phrase this in a question. It may become just a comment. So my agency is in a county of 8,000 people, but we happen to have a US 75 and I-35 who are owned by a certain cartel. Owned, I put in quotation marks. I could see this shall becoming an issue where the cartel decides that we'll just make sure we chill that effect that's going on with interdiction that's happening on either of those avenues by sending up our $5,000 an hour attorney to combat every time they get. So my little county of 8,000 is not going to be able to deal with that. So my concern becomes on the shall or may, if it's hinging on whether law enforcement made a mistake, I guess we should go along with that. But if it's on any mistake or any technicality that could be found where that high dollar attorney can come in and throw a wrench, and now we're going to pay for it every time, I'm going to have a hard time with that. So.
Thank you, Representative Smith. I think Chief Atterbury wanted to comment on the last question.
Please. Thank you very much.
Daryl Atterbury, KCP. Our position would be that there would be an equal application of the law for all people and not based on a jurisdiction that's smaller than some other.
Representative Carmichael, did I see you raise your hand?
I think I could ask the question, Chief Atterbury, wouldn't you agree that the law ought to apply equally to big cities, little cities, counties, the state? Everybody ought to be equal in the eyes of the law.
Yes.
Okay. Well, that's what I think you just said. I had to ask it as a question. But we endanger disrupting a carefully crafted, tenuous compromise by skewing the agreement as it relates to attorney's fees. And we could easily see a loss of support for this bill. I think we ought to respect the work that's been done by Chairman Owens and a host of other people in this room. And it came from Mark Bennett, my district attorney, former Assistant United States Attorney and the present director of the KBI. And I think maybe we ought to respect their judgment in that regard. Thank you.
And just to reiterate, we're in opposition, but that's a really soft opposition. We like 99% of this. That's one thing that we thought that might be a stumbling block that could be handled in a different way. But we wholly respect Mr. Mativi and Representative Owens, the director. Both of them did a stand-up job at representing us and you in this process.
And just a quick further question from you, looking at your testimony, you also mentioned the seizing agency transferring the weapons to the federal firearms dealer. Did you want to mention that?
No.
Okay. Good to know.
Thank you.
Okay, committee, any other questions for anybody? Okay, then I think we will close the hearing on House Bill 2606. Committee, we will not, I'm sorry. Yes, you're welcome to come. Please tell us your name.
I apologize. You should have received my request to to testify yesterday, and I don't know what happened with potentially email problems, or I don't know. But anyway, my name is.
Having trouble with people spelling things correctly. I'm not saying that's what you did, but I know that that has happened at times.
My name is James Bain. I'm with the Kansas Racing and Gaming Commission.
Okay.
And I appreciate the opportunity to speak, and I will try to make it quick because everyone's trying to go, and I appreciate you squeezing me in. Our position is this one-size-fits-all proposal that is HB 2606 is not practical for gambling law, and we ask that gambling crimes be removed. It seems like all crimes are being shoehorned into one bill that's designed for drug forfeitures, and we would just like to see a little more time to talk about unintended consequences about other types of crimes. We have also have the issue with the fee proposal, and we are the ones that this morning brought it up as a penalty to the agency. And I used the example this morning that every lawyer in this room has a case that you can think of that the investigation was done properly, the facts fit together like a puzzle, the witnesses were credible, the closing argument was compelling, and you lost the case anyway. And to paint the government in the corner on every case to have to choose between gambling, this attorney fee penalty, or holding someone accountable for breaking the law, that's a tough place to paint the government in on every single case, because you just don't know when that good case is also going to lose. On the issue of the clear and convincing evidence, what sets gambling crimes apart from drug-related crimes is oftentimes gambling crimes are committed in a location that is also a legitimate business. Gas stations, bars, liquor stores. That's where we see illegal gambling machines that I'm sure you all may have seen in your cities and counties. The reason that's problematic is because there is a legitimate business that can easily commingle funds. And the commingling of the funds makes it easier for that illegal gambling operator to meet or defeat a clear and convincing standard and evade consequences for the forfeiture by commingling ill-gotten gains with the legitimate business and concealing the nature of cash received, that cash received and cash in the business. The final concern we have is this reduction in time from 45 days down to 14 days before the case has to be sent to the county attorney for on a request for forfeiture. The concern from our standpoint is the investigation remains at the state agency while the request for forfeiture goes to the county attorney. And that disconnect may cause issues with the issues with the investigation, issues with the claimants. Oftentimes in that 45-day period, we're getting calls from the claimant's attorney. We're sharing information. We are beginning to negotiate a settlement. And so by then disconnecting the investigation with the forfeiture may cause that claimant extra time trying to figure out where the case is. And I could take it a step further. If it stays with the agency for 14 days, goes to the county attorney for 14 days, back to the agency, over to the attorney general that has 14 days, now back to the agency again, who then contracts out the forfeiture action. That ping pong ball, no claimant is going to figure out where that case is at every stage. And so that's complex, adds to the complexity, and it adds to the inefficiency of forfeiture that we have heard about. And so I don't think it makes anything simpler. Keeping it in one place for 45 days, very efficient. Everyone knows where to find it, and it keeps the investigation with the forfeiture. For things like finding the lien holders, that takes time. Additional search warrants on machines, we oftentimes get multiple search warrants. We have a dozen or more machines. We have to get search warrants to go inside the machine and pull the electronic data that's inside. And so I think keeping the investigation and the forfeiture together for as long as possible is positive. One last note, and I would just say that The current law of forfeiture has been successful for the Kansas Racing and Gaming Commission. Since 2013, we have seized almost 1,300 illegal machines throughout the state, mainly the work of one agent who does those investigations. So current law is working for gambling crimes. And we would just ask that gambling crimes be exempted or more study looking at the other types of crimes that are involved in forfeiture and not just drug crimes, or exempting all the other possible types of forfeitures that are out there. Thank you.
Thank you. Okay, I just have two requests. One, could you say your name and spell it to make sure that we get that down?
Yes, Edward James Bain, B as in boy, A-I-N.
Okay, thank you. And then my other request is that you resend your testimony so that we can actually see your actual written testimony. And I do think we have a few questions.
Thank you.
Representative Owens.
Thank you, Madam Chair. Mr. Bain, I believe we've had one brief conversation, but remind me again of your position with Kansas Racing and Gaming.
Staff attorney.
Your staff attorney. Okay, so this, and forgive me because this really came like literally out of left field, right? And so this is a topic that we've been working on for years. Have you testified on any of the civil asset forfeiture bills in the past?
No. And we went to the hearing in December and certainly would have liked to have been involved, and didn't get an opportunity to testify.
How long have you been a staff attorney with Racing and Gaming?
Since last April.
Okay, so arguably you're new to kind of the whole conversation around what's going on. Okay, that helps me add a little bit more context. Well, certainly appreciate your thoughts. From my opinion, again, because we've struck such a balance with this legislation, I certainly don't think that we should be exempting any specific organization or crime from it. I think a constant, consistent application of our civil asset forfeiture process is in order. But I do appreciate you raising your concern, sir.
We have other questions, committee. Representative Schreiber.
Just, and it's not for Mr. Bain, but just an overall question, if anybody had it. Is there a total value that is collected through civil asset forfeiture annually in Kansas, average, not the exact figure or anything?
Representative Owen.
Yeah, if I might. So if you will, and you can find this pretty easy online, Kansas Bureau of Investigation has a repository, and that information is available. Also, we receive multiple reports from the years that they've compiled that data that I can share with the committee, and then it can be disseminated.
That would be great. Thank you. Any other questions for Mr. Bain or Representative Carmichael?
Mr. Bain, does your agency report to the database that was just referenced by Chairman Owens?
I believe we do.
The KBI database?
Yes. I think, although no one could hear the lady on the second row, but she says yes, they do, whomever she may be.
This is Judy Taylor, General Counsel at the Kansas Racing and Gaming Commission.
Okay, thank you. Thank you for that. Did I see another question over here? No. Representative Mond.
Thank you, Madam Chair. Mr. Bain, I was wondering, I know this is the official hearing on this bill, but we had an extensive hearing during the interim over the summer on this matter. I was wondering why the Gaming Commission didn't come to that hearing and present these issues, because it could have impacted the way this bill was crafted, because we did a lot of work on it.
And so, as far as for my radar, this only came on in December when we found out about Representative Owens' committee and attended that day. And as Mr. Owens pointed out, we visited that day, and very gracious, and listened to what brought up some concerns that day.
I appreciate it. Thank you.
Okay, and committee, any other questions for Mr. Bain? Okay, thank you.
Thank you.
And we'll look forward to reading your testimony. Okay, committee, I'm going to close the hearing on House Bill 2606. Thank you, everybody, for coming, for the testimony, especially for the work of the Judicial Council Advisory Committee and the Interim Committee. We really appreciate you've made our job much easier. Okay, committee, we're not going to work any bills today. We may work some bills tomorrow. I know that might seem harsh with what's going on tomorrow, but it is a possibility. And if we don't work them, we will try to squeeze some of that in where we work the bills on Thursday. I will give you a couple numbers just so you know what to be looking for. 2660, which is the Secretary of State's bill we heard yesterday. 2592, which is the Cora bill that had to do with the fees for Cora. 2675, that's the third party visitation. 2599, I'm sorry, the 2599 is the Cora bill. 2592 is the age verification bill. 2660.
I'm sorry, didn't quite hear you on that one. Thank you.
Okay. 2660 Secretary of State. 2592, which is the age verification bill. 2675 third party visitation. 2599, which is the Cora funds fees. 2676, and that is 2676 is the second of the suicide assist bills that we heard. Those are ones that we may be working, just to give you a heads up about that. Again, if you think you might have amendments, please get with Natalie. We will also be working this bill for today, but that probably won't be until Thursday or Monday. So, okay, committee, thank you everybody for your hard work, and we're adjourned.